Okay, I'm going to go ahead and start. Those of you who are on time, let's talk about a change that came along to the Code of Ethics. And changes usually don't take place until January 1st of the next year, but they added this one in November 13th, and um, it took effect immediately, and it goes like this. Now, I did not put a link for the Code of Ethics in there because this wasn't out yet. I just received it myself this morning. So you can Google if you want to look at Article 10 of the Code of Ethics. You can Google National Association of Realtors Code of Ethics 2021 and you can pull it up. Before we actually get into that, I want to make an announcement. If anybody has stored anything in Instanet, at NVAR, if you have anything stored in Instanet, you need to download it and get it out of there by January 1. Instanet is going away and it's being replaced by Remine, Remine. You can Google nvar.com/Remine and read about the new system and transfer your stuff over there. Okay. So this new standard of practice 10-5, it reads, must not use harassing speech, hate speech, epithets, or slurs based on race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. And when this was first proposed, it caused quite a stir. Uh, People are either for it or saying that you're infringing on my personal um, protections under our Constitution. So I want to take some time and go through this. I discussed it with Johanna and Dave. The company will be coming out with a policy on it. But let me share with you what Article 10 itself says. Shall not deny equal professional services to any person for reasons of race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. Those are the protected categories under fair housing. I also want to point out in the state of Virginia this year, uh, our fair housing law changed, and the state of Virginia now protects sexual orientation and gender identity, as well as source of income and veteran status. So if you weren't aware of those changes to our state law, they are now protected categories. Okay. Article 10 goes on to say realtors shall not be parties to any plan or agreement to discriminate against a person or persons on the basis of one of the protected categories. And that's whether it's employment or not. Now, here's the deal. Um, this was really inspired by the demand for social change. And there was quite a few complaints coming out received by NAR relating to discriminatory conduct and language, not so much in the sale of real estate, but out in the public on different sites, etc. So this Article 10 has now been clarified that the denial of equal professional services to members of a protected class, including the speech or epithets, is protected, and it's remember you're a realtor 24/7. It's not just while you are working. So what they've decided, and they made a change. Now you wouldn't have it. You would probably wouldn't have the information that I have, but let me share with you from professional standards because I am a a member of the Professional Standards Committee at NVAR, and I have the policies and procedures manuals. But there was a change to policy 29 of the Code of Ethics and Arbitration Manual. And policy 29 was amended to expand the applicability of the code of ethics to all realtor activities. And the rationale for that, okay, before this change, it was limited to only real estate activities and transactions. But now they're saying this revised policy expands applicability to all your activities. It doesn't have to be real estate related. So when you go out on YouTube or post something or LinkedIn or Facebook, wherever you're putting it, if it is deemed to be uh, any kind of a hate speech or anything along those lines, you're going to be covered by the code of ethics. Now, remember, it's code of ethics that deals with membership at an association of realtors. And also remember, the code of ethics is only enforceable against someone who belongs to an association of realtors. Okay, so not every real estate agent belongs. So just because you see something posted out there by someone that's a real estate agent, they may not be bound by the code of ethics. Now, this new standard of practice was adopted, and the rationale behind that is the proposed standard of practice directly flows from the requirement to not deny equal professional services or parties to a plan to discriminate. So what they're saying is the hate speech, or et cetera, might indicate that you would not take a client from certain protected classes or not treating them equally if you were to deal with them in real estate. So they're saying doesn't have to be real estate related activity. Okay. Now they also made a change, and they made a change to what we call the definition of public trust. Okay. And that's been expanded to include all discrimination against the protected classes under Article 10. Public trust is one of those things. If I'm on a hearing panel and we think public trust was violated, then we have to further report this from a ethics hearing to the real estate commission. Okay, and if in fair housing, if it's a fair housing one, maybe even to HUD. So we have further duties on a hearing panel other than just the violation of Article 10 itself or any other article. Now, I want to share with you also from our arbitration manual. Standard practice of 10-5 is not focused on types of speech that might be subjectively deemed offensive or discriminatory by one person and not another. The standard of practice is based on very particular types of speech that are directly connected to the protected classes of race, color, religion, the ones we set. Now, NAR actually has a code of conduct and anti-harassment policy that defines these terms. Okay, so harassment, and I'm just going to read you their definition of harassment. It includes inappropriate conduct, comment, display, action, or gesture based on another person's sex, color, race, religion, national origin, age, disability, sexual orientation, gender identity, and any other protected characteristics. So examples of harassment include, but not limited to, epithets, slurs, negative stereotyping, threatening, intimidating, or hostile acts, denigrating jokes, display or circulation of written graphic material that denigrates or shows hostility towards an individual, group, or protected characteristic. So when I'm on a hearing panel and one of these charges come, we have specific definitions we have to look at to see if it would fit in there. Now, sexual harassment is not only physical acts, but also verbal and nonverbal physical acts. So sexual harassment, by definition in our manual, sexual innuendos, suggestive comments, jokes of a sexual nature, sexual propositions or threats. Okay. nonverbal sexual harassment, sexually suggestive objects or pictures, graphic commentaries, suggestive or insulting sounds, leering, whistling, or obscene gestures. In similar fashion, we also have a definition for hate speech, epithets, and slurs. So hate speech that is intended to insult, offend, or intimidate a person because of some trait as race, religion, etc. Epithet, characterizing a word or phrase accompanying or occurring in a place and name of a person or thing, disparaging or abusive word, and a slur, insulting or disparaging remarks. There's no place for this anywhere in public or private life as far as I'm concerned, but as a company, we want to make sure that everybody understands this new policy out there. Be very, very careful in what you post online, okay? It doesn't mean that you can't still have an opinion. So NAR is holding 6 webinars on this stuff. And out of that first webinar came these questions and their answers. Misgendering. What if someone appears to be one gender but prefers a pronoun like they or the opposite of what they appear? Is that a violation of the code of ethics? And what they're saying is, for me to inadvertently say the wrong thing when they prefer to be called they is probably not a violation of the code of ethics. But what is if I simply want to reiterate that the solution is I do it on purpose. It's not a slip, it's something I do on purpose. And the person is now considering that I'm using this intentionally or repeatedly and maliciously, they might bring a charge. Now, I want to make sure you understand on a hearing panel, just because someone brings a charge doesn't mean that you're going to be found guilty. Okay. It has to be clear, convincing evidence for us to reach a conclusion that you violated the code of ethics. And I can tell you, serving on hearing panels, a lot of these cases, when they come to light and we hear all the information, a lot of people are found not guilty. It's just somebody had thought they did something wrong with the code of ethics, and they just want to have their say in court per se, and we listen to it, and then we come to the decision in accordance with our guidelines handed to us by NAR in the Code of Ethics and Arbitration Manual. You can always download a copy of that if you want. It's about 300 pages long. I'm not sure you want to read that. You probably rather just hear me tell you what it says, right? Another one is same-sex marriage. What if a realtor's religious beliefs oppose same-sex marriage? If they say that privately, could they face an ethics violation? And they're saying no. This does not mean that you do not have your rights as religious beliefs, but saying, so, but what about if you said your religion disagrees with same-sex marriages, and gays and lesbians are guilty of murder according to the scriptures? That would be a problem. Okay, so they're not saying you have to give up all your rights to have beliefs, but watch how you're using it. Okay, so that is what they were talking about here with Article 10-5 that came out. There's been a lot of misconception and misunderstanding about it when it came out. I've been following some of these different sites where people are saying they're going to leave the association because they've lost their rights and they're getting into our personal life and all, and that we have protection of free speech in the United States. And yes, you do, but a private organization can control its members, and that's basically what they did here. Now, articles have come and gone. If there's enough people that disagree with this in the future, they may re-examine it, but we do have Article 10-5. Okay. So please watch what you post, and what you say, and that type of thing. Anybody have any questions about this new Article 10-5? Now, Dave felt strongly enough, and Johanna, that we needed to cover this. So, you know. Yeah,
I have a question, Larry.
Okay.
What about political affiliation or political beliefs?
That is not a, so politics is not covered under Article 10. Your race, color, religion, sex, handicap, familial status, national origin, and sexual orientation or gender identity. So it has to be one of the protected categories. Okay. There's actually a webinar being put on today at 2 o'clock between the NVAR's president-elect Reggie Copeland and NAR, that if you wanted to go on the NVAR's website and hear further on this, I'm not getting into as great a detail as they will. I'm actually teaching broker CE this afternoon, and my whole class is going to be in on that webinar to hear explanation. And if anything else comes out of it, I'll alert our agents. But you know, I don't think we've had a problem with it. But they said they gave an example of a confrontation between a realtor and some people in the public, and the realtor was, wearing career apparel, etc., and said some insulting things on camera. And once if a small percentage of people say something like that, then it comes back where they're thinking all realtors are that way, and that's what led to this. All this unrest, etc., social change, demand led to this change. Any other questions about this? Okay, well, so since we're here, that's what I wanted to cover on this, but anybody have any questions for Ask Larry today? Because we haven't had a session because of the holidays. Anything you need to discuss?
Yes, Larry.
Okay.
Good morning.
Good morning.
What is the definition of developed land versus undeveloped?
Developed land has structures on it, or improvements on it. It could just be the streets, the curb and gutter in the streets are in, no houses. So undeveloped has not been disturbed.
So undeveloped means it could have access to utilities.
Well, not necessarily. So when it's undeveloped, that's why when you write a contract on a piece of land, you have to have your feasibility studies to allow you time to make sure that there's access and what the cost would be. Because the land could even be landlocked where those aren't available. So that's why we have that study period for the party to go and make sure all that stuff is available. There's a difference between zoning and what they might allow in the future. So there's a lot that goes into it with that undeveloped land, and there could be restrictions like if you were out in Maryland now and you had a piece of land, Ellicott City, where they've had all that flooding. They've changed all the zoning around there as to what can be developed without submitting floodplain control and all kinds of stuff. So there's a lot that goes into undeveloped land.
I see.
Okay. If you get ready to do something like that, let me know and we'll discuss it further.
Great. I will do.
Okay.
Thank you.
Good morning, Larry.
Good morning.
Hey, way to rub it in that you're in the 70s and we're here in the 30s and 40s, huh?
I'm bringing some warm weather back for you.
Yeah. Hey, got a quick question. If there's a deal that's being handled by attorneys, and it says um, offers or will be reviewed by a third party, would the third party be the attorneys that are dealing with the sale of that property, or what would third party indicate?
Well, it could be just about anything. I've had third party approval where it was the parents, especially with certain cultures. The parents had to do it, or I've even had situations where the high priest had to come in and do the ceremony that they do to make sure that the property was okay for the person to buy. But if it's attorneys involved, it's probably third party review by the attorneys.
Okay.
Yeah.
Yeah, so it wouldn't be a bank or anything. It was just because I think what I researched on this property, it's already paid off, but it was left to an estate. So I guess the attorneys would be
Yeah,
the
the attorneys,
parties.
well, in that instance, the attorneys have probably been appointed to represent the estate. If not, like my father passed away, I was appointed by the courts to be the administrator. So, but if I hadn't been administrator, then the courts would have to review it. So it could even be the courts have to review it.
Okay.
So, but it's more than likely in that instance, it's probably some lawyers have been appointed to represent the estate, and
Okay.
they have the final say.
Okay, thank you.
Okay. Any other questions?
Hey, Larry, good morning. I have a
Good morning.
question.
Okay.
Moving from Instanet to Remind.
Uh-huh.
In Remind, they only show NVAR forms. There is no, Virginia Association Realtors forms.
Yeah, well,
Have you have any idea? Are they going to add that too?
they will not add VAR forms. You will have to still go to VAR's website. So as you can go to VAR's website as a realtor, and you need your NERDS number, your national ID number, and you capitalize your last name, and then you have access to all VAR's forms on their site. Let me warn you, don't try to combine VAR forms with NVAR. There's a few forms that I like it at VAR, sight unseen form, where your buyer would sign saying they're buying this sight unseen and relieve you of the liability. They have one for delivery of the check to the title company, an acknowledgement they've received it, things like that. But there's a big difference between VAR forms and NVAR forms, in that NVAR forms, we have time as of the essence in our contract. VAR does not, and that changed the interpretation of the contract dramatically. VAR, it's like, we'll get there sometime around settlement date. This is what we're shooting for. NVAR, if you miss the settlement date, you're in default. So you got to be careful trying to combine the forms. But no, they won't have VAR. Basically, what will happen is just what's on NVAR now will be switched over to Remind. But Remind, I haven't gotten that deeply into it yet, but I've listened to some discussions, and it sounds like some really pretty cool things. You actually can write the contract on NVAR's forms, and all the negotiation goes back and forth, and it's changed in the system so that you don't have a contract that's marked up back and forth, and then it'll print the final contract without all the hash marks and all. A lot of different things you can do with Remind. So if you haven't checked into it, please do. But key to it is download anything you have saved right now. If you have any cases saved in Instanet, download them so you can move them over to Remind. Okay. And if you go to nvar.com/Remind, they have a lot of information on Remind. Okay.
Okay, thank you.
Mhm. Next Wednesday at 11, we have form changes again. They happen twice a year. So we'll go over and I'll make sure you have a copy of all the new forms. But next Wednesday, we'll just take a look at the changes to NVAR forms that go into effect January 1, 2021. Okay. Any other questions today?
Yes, Larry, this is Maribel.
Yeah, Maribel, how are you?
Fine, thank you. Okay, I have a question about the HOA.
Uh-huh.
Okay, I have a buyer that is buying a property, and when we got the HOA documents, the property have several violations. One of the violations is that the seller extend the driveway, and they need to cut the driveway because the HOA doesn't allow to extend the driveway. When I send the notice to the listing agents, the listing agents say that when the seller bought the property, they removed that violation because it was approved before about 10 or 15 years ago for the HOA. I called the HOA and the HOA say, yes, it's a grandfather, was approved. The problem is when my client read the remarks that the listing agent put in, the listings, she said that they offer the driveway extending, they can park 4 cars. And my client said it's false advertisement because they say they can park 4 cars because the HOA say that if the house has 1 car garage, they only allow to park 1 car. When I call the HOA, they say yes, they can only park 1 car because the house has only 1 car garage. And we know that right now, but I say my clients, I don't know, you have to resolve that problem after if you want to buy the house, no? Because it's allowed to have the extended driveway, but it's not allowed to park more than 1 car because the house has only 1 car garage. I say when I spoke with the association person, they say, yes, it is ridiculous. You have approved an extended driveway and they only can park 1 car. They say, yes, but I don't know why the HOA approved in the past. It's a grandfather.
Yeah, and so you gave them the right answer. If they want the house, they're going to have to take it the way it is. The fact that it's in the listing agreement, and it says right in the listing agreement, information believed to be true, but it's not guaranteed. There's not really anything you could do to the agent. You might bring a charge, Article 12 of the Code of Ethics, false advertising, but as far as any damages or anything, there is none. So they either have to take their chance, they park cars there later and no one says anything, or, are they using it that way now? The additional cars?
The listing agent said that the seller parked 2 or 4 cars in the driveway. It's no problem because the HOA never check all days if they are 1 or 2 cars parking in the driveway, But
Yeah.
I say my client, okay, they know right now. I say, okay, they put in the HOA as a violation, but in the future, if they don't put, anybody's gonna know what is happening, yeah?
Yeah. Now, in the future, when they go to sell it, they shouldn't be telling people they can park 4 cars. But you did the right thing. Point out to them that you can only do the one. If you buy it, that's, you got to go by the rules. If somebody complains, then you wouldn't be able to have it. Is that the driving force, is the 4 cars, or do they still want the property?
Yeah, my client is gonna buy the property. In the future, they call me to sell that house. I'm not gonna advertise, but if there's no violation, I need to disclose that.
Well, in the future, are you talking about when you list it in the future, would you have to disclose it? Well,
5 years, I don't know, because if no a violation, I have to disclose because it's no a violation. I have.
No, the extended driveway was approved, so it's not a
Yeah.
violation. Just don't
Yeah.
say you can park 4 cars. And then when they get the documents, they'll see that it's limited to 1. Okay,
Okay.
why did it show up as a violation if it was approved? It showed up as a violation because they had 4
I
cars
don't-
parked?
They show a violation. When I call, they say, oh yeah, we need to review the paper. If it's approved, it's not a violation, it's approved. And because he let me know it's a grandfather, I'll say, okay, but my clients can't park the 4 cars, say no, because our regulations say if the house has 1 car garage, it's only allowed to park 1 car. I say,
Yeah.
oh,
Now, in the future, and we're not going to give legal advice to this client, but in the future, if everybody has been parking more than 1 car and they can prove more than 1 car was parked in all these different houses, they probably wouldn't be able to enforce that regulation anymore. But, right now you did the right thing by saying, hey, I'm telling you, it's only approved for 1. Whatever way you use it is, going to be your
okay,
what you decide to do. Yeah.
okay.
In the future, you don't say 4 cars can park there.
Yeah, I know.
Yeah.
Okay.
Well, you get a lot of these. You get a lot of these with these homeowners associations, don't you?
Yeah. Oh my God. my client's close. Yeah. Okay. Thank you, Larry.
You're welcome. Any other questions today?
No.
Okay, if there's no other questions, we're gonna make this a shorter day because I have to start up again at 1 o'clock and teach for 4 hours for the board. But that's what I wanted to talk to you today is about the new 10-5, the harassing speech, hate speech, etc.
Okay, thank you,
So
Larry, then.
if you any instances of that, if you see any instances of that or hear anything, that you think is questionable, please let me know and we'll address it company wise. Okay.
Okay, thank you.
Well, thank you
Thank
guys
you,
for
Larry.
Thank you,
thank you
Larry.
guys for taking the
Thank you,
time for
Larry.
joining me today.
Yes.
Thank you.
Okay, and I'll see you
Thank you, Larry.
guys. I'll be back in the office during this Thursday, so I'll be back up there. So I'll see you guys. Next Wednesday when we go over the form changes. Okay.
Okay, see you next Wednesday. Thank you.
Okay.
Okay,
Bye.
thank you.
Bye-bye.
Bye-bye.
Thank you, Larry.
All right. Bye.